something that is, made from nature, all of that. We did see it in last class. We saw point still, atomic energy, all of that is part of the, you can't call it as a patent. So now, coming back to where we stopped last class, what is patentability? We saw that the particular invention should be a new invention. It should be fresh invention. It shouldn't have been copied from anywhere. So it needs to be novel. Then it needs to have an inventive step. It shouldn't be obvious. So you should have invented something. It shouldn't be obvious that anybody will know what the process is. So it needs to be an inventive step. It should be capable of industrial application. Now, you're sitting at home, if you do something, you can't get a patent for it, because whatever you are creating should be used for the benefit of the industry, and it should be used in the industry. So sitting at home making a machine, it's not patentable. It needs to be used. That's when you can patent an application. It should not attract the provisions of 3 and 4. We'll see what is the provisions of 3 and 4 a little later on. So this is the criteria for patentability. Now, again, who has the right to apply for patent? One, whoever's invented it. So they call it as true and first owner of the invention. So whoever made it firstly, that person can apply for a patent. Second, any person being assignee to the person claiming the true and first owner. Now, what happens is sometimes you're handicapped, you cannot, you do not have a knowledge about how to apply for patent. You assign someone. On your behalf, you tell someone to apply for a patent. So that person becomes an assignee. So that time, the assignee can also apply for a patent. Third one is a legal representative of a deceased person. Now, someone's passed away. When someone's passed away, but there still is an invention and you still want to apply for an invention, so that's when you apply for the deceased person will apply for an patent. Now, in short, once the patent application is submitted, once it's approved, the patent will be valid for 20 years. Now, after the patent expires, the invention is no longer protected and becomes part of the public domain. That means the owner no longer has a sole right to use the invention. Now, in short, is 20 years. So if I make a product and if I apply for a patent today, it'll take some time to receive it. It'll take years. It'll take 1 year, 2 years, 3 years. It'll take even 5 years. But though they have timelines, they have very strict timelines. They never really follow those timelines. But once you receive a patent, it is valid for 20 years. Now, the person, whoever has obtained the patent, whoever's name the patent is received from, will have the sole right of that particular patent. So, that particular invention. So, if I have made a machinery to make biscuits, now I have the right to use the machinery as how I want. In case if some other factory, say I'm working for Pale and I make a biscuit making machinery, I'll give it to my factory. The factory uses it for making biscuits. Now, I have an option to sell the machinery to another factory. Say Britannia comes and asks me, I can tell Britannia, yes, you can purchase the machinery. You will have to give me a royalty for each biscuit that you produce from the machine. So I'm just giving an example. So Britannia, if they agree to it, say for a lease, say 5 years lease or something, I can give it to Britannia, saying that you can use this machinery for 5 years and then you give it back to me. So I have the right to lease my invention to somebody. I have the right to take royalty, ask earn money out of that invention. That is possible. Now, after 20 years, what happens is the patent expires and that comes into the public domain, and use it. So basically, what comes into the public domain is not the machinery as such, but the method in which I have created that comes into the public domain. So, say if Britannia or if any other biscuit manufacturing company was keeping an eye on the machinery. So once 20-year expires, immediately they can get all the details from the portal, how to make the machinery, and they can make it themselves. So the time frame is for 20 years. So this is about who can apply for a patent, how much it's valid, all of that. Anybody's got any queries? Any doubts? Nobody? Okay, let's move forward. We saw the procedure. So the procedure is first you file an application. The publication happens after 18 months. And in case if anybody has any opposition, they kind of object to it. They will again request for an examination. Then the controller will decide whether it has to be granted or not. So we look at things one by one. So first thing is one second. Yeah. Okay. So okay, before coming to that, there is another concept called Patent Cooperation Treaty. Now, what is Patent Cooperation Treaty? It's also called PCT. It is So it is a treaty that has been signed by more than 150 international contracting states. So basically, they tell that with a single application of patent, you have applied for these particular countries. So you've applied for the patent law in those particular jurisdictions also. So basically, you don't have to go to each country and file a patent there. A single application, if you're filing under the Patent Cooperation Treaty, it is considered that you're filing it everywhere. So that's a concept about Patent Cooperation Treaty. Now, first thing is you will have to give, coming to the specifications, you will have to give the complete contents of the entire invention that you have created. You will have to fully and particularly describe the investment and its operation of use and the method in what can be performed in. So basically, any details that you have used to make the invention, you will have to give how many bolts you've used, how many screws you've used, what is the step to step process you need to mention on how you have created it. Next, for what is the invention used for? For what products can you make? How many products can you make in a minute? How many products can be manufactured? And how it has to be done? All that has to be, details have to be given. Disclose the best method of performing the invention. So again, as I said, you will have to give a method of how you have created. You have to write it and give it to them. End with a claim or claims defining the scope of the invention for which protection is claimed. Now, your entire method cannot be, cannot be your invention. So you would have done the process. For example, I'll give an example. It's like a biscuit manufacturing company. Now, I have made a packaging unit. I have made a packaging machine which can stick labels automatically. I'm just giving an example. It can stick labels automatically. Now, what the process is once it's manufactured, it will go into the packing chain of machinery. So it will go into the packing chain, and then my invention will take the wrapper, will cut it in its designated place. It will cover the biscuit. It will put a label. It will put a sticker, and then it will send it for the next packaging. So there, 3 or 4 biscuits will be put together. Then it will be wrapped together in one packet, and it will send for dispatch. Now my invention was putting the label. Now I'm just giving you an example. So if I have made an invention, I have made a machinery which will put labels to all the packaging. Then I will have to mention in the entire process. So I will mention the process, right? The biscuit will come out from the manufacturing unit. It will be assembled in a pack of 4, and then my machine will cover it, put a sticker, and then send it for packaging department. Now all that I will have to explain. I will also have to tell which machinery I am claiming for invention. So basically, I will have to give them the description. I'll have to give them the entire process. Plus, I will also have to tell that this particular method is cost saving. It is saved so much of time. It is automation, and I will have to tell them what I'm claiming as a patent. So basically, in the entire process, only one section or one part may be patentable, because the other parts would have already been patentable. So one part is what I have invented, and I'll have to tell that clearly. Now, to be accompanied by an abstract to provide technical information on the invention. Now, it does not only, I should not only give the details on how to use it, to manufacture it and all that. I will also have to give technical information, as in what I have used, how many chips I've used, if I've used a particular nut, particular bolt. I'll have to give all the details. Everything will have to go into the contents or specifications while I'm making the application. Okay. So next, there is a concept of how a patent specification is prepared. Now, someone's making a patent application, you will have to specify everything. So that's called a patent specifications. Now, a patent specifications can be prepared by the applicant himself or his registered and authorized agent. Now, like how you have a company secretary, how you have a chartered accountant, you also have an agent called a patent agent. Now, this particular person is qualified. They have a patent exam, so they will have to write a patent exam, and that's when you become a qualified patent agent. Now, what does a patent agent do? They will help you do this patent specifications. They will also help you to make an application. They will also suggest how you need to make an application, where you have to apply to, who all you have to submit it, what all drawings you have to submit, everything. They will help you out with the entire process from start to end. And then, if there's any objections, they will reply to any objections. They will reply to any examinations. They will do all that work for you. So basically, you do the invention, you catch hold of a patent agent, and he will do everything for you. And then he will even tell you once you received your patent in your name. And again, what has to be done after that, all of that, they are certified agencies who will do it for you. Now, the patent specification generally comprises of the title of the investment, technical field, drawings, backup, prior art, solution provided, all of that you will have to mention and give it in your application. Now, again, you whatever you have invented, you also have to give all the drawings, all the backups, step by step process of how you have to use the particular invent the particular invention and use the particular invention. So this is something called patent specifications. Anybody's got any doubt? And so so far in whatever we've seen? Okay, let's move ahead. Now, an application. So after the patent application you have done, the patent gets published. Now, published is they won't publish the entire information, but they will publish information that this particular person has applied for a patent to manufacture biscuits. So they'll just give a broad look on it, and they'll give some basic details. Now, every application for patent is published published after expiry of 18 months from the date of its filing or priority date, whichever is earlier. However, the following applications are not published. So basically, after 18 months it's published, applications in which secrecy directions is imposed. So in case the government or mainly the government, in case the government feels that this particular invention of making biscuits should not be disclosed to anybody, then it will not be published. Application which has been abandoned, that is when a provisional application has been filed and complete application has not been filed within 12 months from the date of filing of provision application. And C is application which has been withdrawn 3 months prior to 18 months. So basically, these three items are not, those patents will not be published. Now, what happens is someone who creates, someone who's, creates a machine. Sometimes he feels he's created a machine. He feels if he gives the entire information immediately, the process might be leaked. Someone else might copy it and file their patent application. So what they do is first they file a provisional application. So basically they'll just give a broad view of the of your patent, and then what happens is after giving just a broad view, within say 12 months you have to submit your complete application. So provision is just basic information, complete is the entire information you will have to file. Now, someone doesn't file the complete application and only has provided provisional application, those kind of patents also will not be published. Again, if someone withdraws their patent for any reason, that also will not be published. Okay, no application for a patent shall be examined unless the applicant or any other interested party makes a request in the prescribed manner for such examination within the prescribed period. Now, once the patent is published, that's after 18 months, there will be time for people to submit their requests, objection requests. So they kind of tell that, this method has already been there in the market, or this method has been copied from my invention, or I have already, I have a patented process, they have just copied it. So all of that is in this. Once the patent is published, anybody who has any obligations can request for an examination. Now, a patent application will not be done for an examination until a request is made. Yeah. So whether an application and the specifications of such documents relating to are in accordance with the requirements of the Act. So basically, in case if somebody makes an application for examination, they will check whether everything is properly, and they will then only grant for examination whether there's any lawful ground of objection. So if anybody has got any lawful ground for grant of patent, that's when they will only entertain such examination. The result of an investigation made under section 13, we will all that we'll see it in the later on. Any other matter which has may be prescribed. Now, in case of the report of the examiner is adverse to the application and requires any amendment to the application, specific documentations the controller shall, before proceeding to dispose of the application, communicate the gist of the obligation and give him an opportunity to be heard. Now, the controller will do his entire investigation, and he'll decide that, okay, there is a patent which is already existing, and we cannot give this patent. So he will ask the person, he will tell the person these are the obligations, and whoever's making an application will have an opportunity to be heard, and then he will dispose of the case. Now, there are times when the controller has gone back to the person who's applying for an agent and tells that you will have to make modifications to the process. This process is copied, it looks like copied, can you make a little change, can you make this change, that change? He will ask, if you agree to make those changes, then they will approve it. Otherwise, they will refuse your application. Now, opposition to the patent. Now, how a patent is got opposed is the applicant for the patent or the person under or through whom he claims wrongfully obtained the invention is the person who gives an opposition. So, if I feel the patent who has filed an application is wrongfully filed it, I can object it. And invention so far is claimed in any claim of the complete specifications has been published before the priority date of the claim. So basically, the date that you file will be your priority date of claim. So before that, it was already published. Patent has already been filed. Then it is an objection. Okay. C. The invention so far as claimed in any claim of the complete specification is claimed in a claim of a complete specification published or after the priority date of the application's claim and file and pursuant of the application for a patent in India. So basically, anything which is already being claimed, as I said, if anyone's again filing it, then it becomes a duplication and it will be opposed. Invention so far that claimed in any claim of the complete specifications was publicly known or publicly used in India. So basically, whoever has submitted their application for patent, that process was already known in the market. It was already claimed long back, and 20 years already has completed, and now it is in the public domain. Such patents also you cannot claim. Okay, and the invention, whatever you have claimed, is very obvious and clearly does not involve any inventive step. That time also, if anybody opposes to that, opposition of claim can be put for that. So those are the 5 points in which you can claim an opposition. So there are more points. Points to the opposition. Now, any subject of any claim of the complete specification is not mentioned within the meaning of the act. Again, you can oppose it. The complete specification does not sufficiently and clearly describe the invention or the method. That time also it can be the patent can be opposed. So basically, you have not given the entire specification of what you have created. You have hid important steps. That time it will be opposed. Then the applicant has failed to disclose to the controller the information required or has furnished the information which has any material particular was false to his knowledge. So basically, if the controller asks for any information and you do not submit it or you submit false, then it is an issue. The case of conventional application, the application was not made within 12 months from the date of first application. So basically, from the provision application to the complete application, 12 months was already passed and you haven't submitted. The complete specification does not disclose or wrongfully mention the source of geographical origin. Now, if you have, say, any, if you have received any mineral from say Tamil Nadu, but you'll write, I have received this particular thing from Kerala. If you give the wrong geographical origin for that also, they will oppose the claim. Okay, the last part is the particular process that you have claimed for the patent. It was already in use in some, tribal, local, or some community in India has already used it, and even elsewhere also they have already used it. It's already there. People know it orally but have never applied for a patent. Such requests also cannot be patentable. Now, these are the points which opposition for the patent is available between the controller and any other third party. Okay, anybody's got any doubts in the entire chapter? They have not. So basically, there are timelines, but they have not mentioned, because in real life it really does not work that way. So it can take 2 years, it can take 5 years, it can take 10 years also for a patent to be published. for your patent to be approved. So they have not really mentioned any timelines anywhere. Um, then and there, they have said, within 18 months it'll be there, all of that. But then nowhere they have mentioned that, within so many months or so many years, the controller will approve the patent, because um, it takes a lot of years for them to do their research, to do an examination, and then approve it. So it is not an easy task. So they take a lot of time to actually do the entire process of, from an applying for a patent, from, to getting it approved. Similar thing is for the other ones also, like trademarks, copyrights, all of that. It takes time. So they really don't specify anything like the act saying that within 1 year it has to be approved, 2 years it has to be approved. They don't usually specify. The next one is residents not to apply for patents outside India without prior permission. So basically, one second. Anybody who wants to apply in another country, now we read about the PCT also, but even if you want to apply there, you need to take the government's permission. If the invention has been made in India and you want to take a permission in another country, like say UAE or the US or the Canada, you want to apply for the patent there also, then you need to take prior permission before you make the application. Okay, so if I am a patent and I have applied for a patent and I have received the patent, what rights do I have then? I have the exclusive right to prevent third parties to use the invention. Now, it says act of making, using, offering for sale, selling, importing, purposes that product in India. So basically, no one can make my product, no one can use my product, no one can offer it for sale, and no one can sell anything that's produced from that. So basically, I have exclusive right. If I want, I can always give consent. I can lease out my right. I can sell my right to people, saying that you can use this machine for the next 5 years. After that, you can't use it. Now, all of that, I have got rights. Now, what if someone actually uses it? Then I have a right to sue them also. So if someone uses it without my knowledge and I get to know that this person is using it and or making it and selling it, I can always file a case against them. Now, always patent is always a patent of a product, patent of a process. So basically, a final product. Say, I'm just giving you an example. A particular screw. Now, if that model is patentable, it's a patent of a product. If the process how to make a screw, if I have applied for a patent of how to make a screw, that process is also patentable. Okay, anybody's got any doubts so far? Can we move ahead? Let's move ahead. Now, grounds for revocation of patents. Now, what happens is the controller has a right to revoke the patent. Revoke is nothing but will be cancelled and will be taken back. Now, patent is there for 20 years. Now, within say 5 years, they realize these particular grounds have happened, and because of that, they have to cancel the patent. They will be able to do it. They have the rights to cancel and revoke the patent. Now, all these points will be important as a point of view from the examination, because they all are point by point wise. So, you don't have to remember every line, but you will at least have to remember what is the concept behind each line. So basically, you can tell someone has made a false allegation. So you don't have to write where a false suggestion or representation was made. You can just write a false application or a false process. Like that, you can write small words, but you should remember all these points. And this is a very important point of view in the exam for the exam. So just remember these points. Claim as earlier priority date, which is included in the complete specifications of another patent granted in India. So basically, when you're making an application, you have given the entire data, but a patent was already granted prior to your application. Then they will revoke your patent, where the patent application was filed by a person who is not entitled under the provision of the act. Now, if I am not a true owner, if I'm not an assignee, if I'm not a legal heir, then if someone makes a patent claiming it their own, they cannot claim it. Where the patent was wrongfully obtained and the rights of a petitioner or any person under through whom he claims were contravened. So basically, I have made something, but someone else claimed for the patentee, then it is not right. So they will revoke it. 1 second. When the subject of a claim of the complete specifications is not an invention within the meaning of the act. So basically, they have given it, they have granted of the patent, but then they realize that when you look at the entire complete specifications, then it is not an invention at all. So they will revoke it. Where the invention that has been claimed is not new, and it is already publicly known. So they have granted the patent off, and then they realize it is not a new patent. Then they will revoke the patent. Where the invention that is claimed is obvious and lacks any inventive steps. There is no inventive step. Where the invention is not useful. So you have created something, but it's not useful. So then they revoke it. Where the invention and the method by which it is performed is not sufficiently and fairly described by complete specifications. So basically, not sufficiently and fairly. So basically, you've not given anything. So that time also, your application can be revoked. Where the scope of any claim is not defined properly and based on the matter which is not disclosed in the specifications. So you have not given any scope of any information. You have not given it in your application properly. Where a false suggestion or representation was made, when any subject to any claim of a complete specification is not patentable under the act. So basically, any particular method or something that you have claimed is not patentable, so they will not issue the patent for you. The invention is being claimed was secretly used in India before the priority date of claim. So basically, it was very secret kind of an invention. That's why it wasn't published. And then you invent something and you claim it. It cannot be done. Where the information required under Section 8 has not been disclosed by the applicant of the patent to the controller. So again, you've given false information. You have not given proper information. That time, they will your patent will be revoked. Where any direction of secrecy passed under Section 33 has been contravention, where any permission to amend complete specification was obtained by fraud. So basically, when the controller asks you to amend any specifications, you kind of amend and you tell you've amended. That's not right. The complete specification does not disclose or mention the wrong source or mention the wrong source. So basically, all information, whatever you have mentioned, is all wrong. Does not given all the details. They will revoke it. The invention was anticipated having regard to the knowledge which was available within any local or indigenous community. And again, if it's already been used by any community or anybody, that time the invention cannot be given a patent. So those are the grounds for opposition, revocation. Now, there's a concept of compulsory licenses. Compulsory licenses are authorizations given to a third party by the Controller General to make, use, sell a particular product or use a particular process which has been patented without the need of permission of the patent owner. So probably that's a very useful process which has to be used by all the pharmaceutical companies. You have to sanitize your medicines. You have to do this. You have to do that. All of that. So those are compulsory licenses. So at that time, you do not have to take permission from the patent holder. You can use it based on the permission from the Controller General. in case if the patent has not been used for a very long time, the Controller General, so basically the patent has been granted but has not been used, then the controller has a right to revoke that particular patent. Now, patent agent, I've explained who a patent agent is. Now, patent office and establishment, the central government has a right to establish and open patent offices throughout the country. So, the central government is responsible to open patent offices. Appeals to High Court. One second. Yeah. So, any controller, any decision of the controller that anybody is not happy with, they can approach the High Court. Like every time we see a district court, special court, or tribunal, something, in this case, it is not that way. If you're not happy with the controller, you can apply to the High Court. You can appeal to the High Court. Okay. So that's all. Anybody's got any doubts in patents? Whatever we have seen so far?